Modern Real Estate Practice, page 66. Page 67. Unit 5. Forms of Real Estate Ownership. Learning Objectives. When you have finished reading this unit, you will be able to define and explain the distinction between ownership in severalty and co-ownership. Describe the various forms of co-ownership in real estate. Describe the key elements of trusts, partnerships, corporations, and LLCs. Identify and describe the types of property ownership for common interest properties, and define the following key terms: common elements, community property, condominium, cooperative, co-ownership, corporation, general partnership, joint tenancy, limited liability company, LLC, limited partnership, partition, partnership, PITT, PIT, right of survivorship, separate property, severalty, tenancy by the entirety, tenancy in common, TIC, timeshare, townhouse, trust. Overview. Real estate buyers must determine the type of ownership that best fits their needs. The choice of ownership will affect the ability to transfer the real estate in the future and has tax implications as well. While real estate professionals should be able to identify the basic forms of ownership available, it is up to the prospective buyer to explore the options and make a decision, most likely with the advice of an attorney. Page 68. Although the forms of ownership available are controlled by state law, real estate may be held in one of three basic ways. They include ownership in severalty, one owner, co-ownership, more than one owner, and ownership by a trust, property held for the benefit of another. Ownership in severalty. Ownership in severalty occurs when property is owned by one individual, corporation, or other entity. The term comes from the fact that a sole owner is severed or cut off from other owners. The owner in severalty has sole rights to the property and sole discretion to sell, will, lease, or otherwise transfer part or all of the ownership rights to another person. In practice, Rohan has inherited a condominium from his parents. Rohan owns the property in severalty, making him the sole owner of the condominium, entitled to all of the rights of ownership. Co-ownership. When title to a parcel of real estate is held by two or more individuals, those parties are called co-owners or concurrent owners. Most states commonly recognize Various forms of co-ownership. Individuals may co-own property as tenants in common or joint tenants. In some states, if co-owners are married or in a recognized civil union, they may co-own property as tenants by the entirety or as community property. Forms of co-ownership. During the lifetime of the co-owners, there may be no apparent difference between the various types of ownership. Only when the property is conveyed or when one of the owners dies will the differences become apparent. Tenancy in common. A parcel of real estate may be owned by two or more people as tenants in common. In a tenancy in common, TIC, each tenant holds an undivided interest in the property. The co-owners have unity of possession, meaning that each owner is entitled to possession and use of the entire property, even though each holds only a fractional ownership interest. If there are two co-owners of a property, for instance, and no other division is specified in the deed conveying the property, each owns 1/2 interest. It is the ownership interest, not the property, that is divided. The deed creating a tenancy in common may or may not state the fractional interest held by each co-owner. If no fractions are stated, the tenants are presumed to hold equal shares. For example, if 5 people hold title, each owns an undivided 1/5 interest. Each of the shares can also be held by a couple, whether married or in a civil union. Because the co-owners own separate interests, they can sell, convey, mortgage, or transfer their individual interests in the TIC without the consent of the other. Forms of co-ownership. Tenancy in common, TIC. Joint tenancy, tenancy by the entirety, community property.